I believe I'm as ready as I'm going to be.
Okay. One thing, do you mind moving the microphone a little bit closer to you, just so we can make sure everybody can hear you?
How's this?
That's perfect. Thank you so much. So we are here on the matter of Childers v. Evergreen Health et al., cause number 24-2-09699-0. I would ask counsel for the defense to make your appearance for the record, please.
Thank you, Your Honor. This is David Norman for defendants Dr. Wu and Evergreen Health.
And Mr. Childers, if you don't mind just introducing yourself so that basically we have a system in here that records what everybody says, and it's important that the Court of Appeals, if they're ever looking at this case, knows who's speaking. And so if you don't mind just introducing yourself, that would be helpful.
My name is Nicholas Alexander Childers. I'm the plaintiff in this case. I'll be representing myself.
Okay, excellent. And I see that you have someone with you at the counsel's table. Can you just introduce that person as well?
This is my partner, Matthew Goldman.
Okay, welcome. I just wanted to put on the record, did you receive the order that I entered yesterday with respect to accommodations for this hearing?
Yes, sir.
So agreed to provide more time, 20 minutes aside. If you take the whole 20, that's fine. If you don't, that's fine too. It's entirely up to you, okay? That you may read from notes or a script or anything that you have prepared, that's completely appropriate, okay? I will, if I have questions for you, I'm going to hold off and ask my questions after you're done. And if you need a few minutes, some time to kind of think about the answer, totally appropriate. We'll deal with that at that time, okay? And as mentioned, you can have somebody with you. I just wanted to make sure that the party that you understand that you should do the talking. Do you understand that?
I'm going to be doing all the talking. At most, they'll just be assisting me with the papers and stuff.
Oh, that sounds good. Okay, and then. And I said I wouldn't interrupt you during the presentation. Do you have any other questions or any other accommodations you'd like me to think about?
If there's something that I'm not understanding due to lack of knowledge, is there any way to get something defined if I'm not sure exactly what it is that's being said?
What we can do is either Mr. Norman can explain what he's talking about in a way potentially to avoid jargon and things. The other thing is I may be able to help answer general questions or explain what I understand Mr. Norman to be saying or try and clarify for you a particular issue. Obviously, I'm the judge and I can't give you legal advice, but I think I can be helpful in maybe sort of explaining things as we go along if there are questions as to something that comes up, okay?
Yes, Your Honor. Perfect.
If you don't understand something, please do, raise your hand or actually, you know what? While Mr. Norman's talking, probably the best idea would be for you to write down a question or if you didn't understand something. And that way then, we can have Mr. Norman clarify when he's done or I can try and clarify the question for you, okay? Just so we don't interrupt Mr. Norman's presentation, and he obviously won't interrupt your presentation, but obviously if you have questions, I think we can accommodate that, figure out how to get that answered. Mr. Norman, do you have any questions or issues with what I've said so far?
No, Your Honor, no issues at all.
Okay. So we are here on the defendant's motion for summary judgment. I have read all the briefing and the pleadings in the case. I'm familiar with the facts, and I think I understand the issues before me. So, Mr. Norman, if you'd like to begin, and if you would like to reserve a few minutes for rebuttal, that would be fine. Did you want to reserve any time?
I'd say 5 minutes, Your Honor.
Okay. So why don't you begin, sir?
All right. Thank you, Your Honor. So defendants Dr. Wu and Evergreen Health are bringing the summary judgment primarily on two grounds. One, it's undisputed the plaintiff did not file a pre-suit tort claim with Evergreen Health prior to filing suit in May of 2024, and then again in July of 2024, which requires dismissal for lack of subject matter jurisdiction under Levy v. State. And part two, if dismissal is ordered, dismissal should be with prejudice because the 3-year statute of limitations expired on plaintiff's claim in November of 2024, or at the latest February 2nd, 2025, precluding plaintiff from refiling the action. So in terms, the court indicated that it had read the materials and is familiar with the factual background, but I'd like to give a bit of a summary because it pertains to some of the issues regarding the statute of limitations.
Okay.
So my understanding is the plaintiff was injured at work on May 3rd, 2021, when they slipped due to dust and fell and landed on their left hip. They were later diagnosed with a back sprain. Accident was reported on May 14th. This is in paragraph 5 of the plaintiff's original complaint. The plaintiff went to the ED several days later and then to Evergreen Health Primary Care on May 24th, 2021, and was seen by a provider. I believe that was Dr. Zender. Starting at least by July 1st, that may have been the Dr. Zender appointment, plaintiff alleges that Evergreen Health providers negligently refused to address persistent pain and clicking and negligently refused Mr. Childers' request for further diagnostic imaging. This is at paragraph 5.3 of the original complaint. Mr. Childers' care by Dr. Wu started at the Evergreen Primary Care Clinic on July 7th, 2021, where again, plaintiff complains that there was a more significant issue in their lower back that was not being addressed and asked again for further imaging, which was allegedly negligently refused by Dr. Wu. That's paragraph 5.3 of the original complaint. Plaintiff also alleges that Dr. Wu did not comply with L&I guidelines at this first visit as well. Dr. Wu was the attending physician for the patient's L&I claim related to the workplace injury and last evaluated the plaintiff October 27th, 2021 in person, and last had any involvement in the patient's L&I claim in November of 2021. Plaintiff claims that they were eventually diagnosed with a left L4, L5 disc herniation on CT in May of 2022, and then had decompression surgery in March of 2024. So in terms of the procedural history as set forth in the briefing, on May 1st, 2024, plaintiff filed their original complaint against Dr. Wu and Evergreen Health, alleging medical negligence against Dr. Wu and unnamed providers beginning at the latest July of 2021. Plaintiff did not submit a pre-suit tort claim to Evergreen Health more than 60 days before filing suit or at all. Now, under the law, all tort claims must be submitted. All tort claims made against a public hospital district must be made to the executive assistant to the CEO before the party can file suit and tort against Evergreen and any of its current or former healthcare providers. On July 26, 2024, plaintiff filed their amended complaint, which was quite a bit shorter. I believe the original complaint was about 100 pages, and the other one was about a tenth of that. On August 6, 2024, the Evergreen defendants filed our answer and affirmative defenses, specifically raising RCW 496. So in terms of the legal argument, the first issue is relatively straightforward. I didn't see much of a rebuttal in the declaration that plaintiff filed in response to the brief. Whether a tort claim is properly and timely submitted before filing suit is addressed in summary judgment. It's a pure issue of law. It's not an issue of fact. Public hospitals such as Evergreen Health, Valley Medical Center, and others, I think Skagit is another one, are municipal corporations subject to RCW 496's pre-suit tort claim requirement. Specifically under RCW 496010 subpart 2, it references public hospitals. And specifically under RCW 496.020 subpart 4, no action can be commenced against a public hospital district before 60 days have elapsed after the filing of an appropriate tort claim. This requirement is jurisdictional and it's interpreted strictly as opposed to the contents of the tort claim itself, which under recent law, relatively recent law, is interpreted under a substantial compliance standard. However, whether the claim is submitted or not is strictly construed. The only appropriate remedy for failure to comply with RCW 496 is dismissal, and this has been affirmed repeatedly by all of our courts. Plaintiff admits in their declaration on page 4 that no tort claim was submitted, and states later in the declaration that it was a mistake. Mistake or not, the necessity of a tort claim is a jurisdictional issue. It's a pure issue of law that's appropriate for summary judgment, and I think that issue is essentially undisputed. The more complex issue is if dismissal is ordered, should it be with prejudice or without prejudice? So this makes up the bulk of the plaintiff's response in their declaration. Plaintiff agrees, however, the plaintiff agrees that all of their claims arise out of healthcare, which means two things. One, they all fall under RCW 770, which is the exclusive remedy here. And two, that means there's this 3-year statute of limitation as defined under 416.350. And it's important because how the claims accrue for a medical negligence claim is different than a normal tort claim. And I'll get to that. So the first issue that I saw in the response briefing is it's an issue of fact as to when the claim accrued. And there is no issue of fact as to when the claim accrued. And there's no case authority cited by the plaintiff in their brief interpreting how claims are accrued in the manner they're suggesting. The statute of limitation in a medical negligence case begins to run at the time of the wrongful act or omission causing injury, not the discovery of the injury. Plaintiff alleges wrongful conduct by Evergreen Health's providers by May 24th, 2021, or at the latest, July of 2021, obviously more than 3 years ago. Plaintiff repeatedly states in their original complaint from that other providers in 2021, including physical therapists, suggested they had a disc injury, further driving their request for additional imaging from the Evergreen Healthcare providers. This means they had actual knowledge at the time, in real time, of the allegedly negligent conduct. This isn't a discovery rule case, in other words. Plaintiff's allegations surrounded direct refusal by multiple Evergreen providers, primarily Dr. Wu, in refusing, allegedly, to order imaging that the clinicians did not think was clinically indicated. Plaintiff's declaration specifically argues that plaintiff contacted Dr. Wu multiple times regarding their fear of a worse injury going undiagnosed. Again, this is a real-time knowledge of the alleged negligent conduct. That's at page 9 of the declaration, Your Honor. This means the action accrued either May 24th, 2021, or at the latest July 1st, 2021, based on the allegations raised by the plaintiff. So I saw reference to the continuing course of treatment doctrine, which is rarely applied. The continuing course of treatment theory can't help here when the doctrine requires that the continual course be of the same provider, the wrongful conduct be the same, and that the last negligent act is within the 3-year period. In this circumstance, you can't allege a continuing course of treatment by, quote, Evergreen. Evergreen Health itself is a legal entity. It cannot directly provide medicine. You don't allege a continuing course theory against a building. It has to be an individual provider. In this situation, there were multiple Evergreen healthcare providers providing care for Mr. Childers over an extended period of time, roughly about a year, a little less than a year. It's undisputed Dr. Wu's care of the plaintiff ended in October 2021, or at the latest November of 2021, if you're going to count email exchanges with the L&I people as care, which legally it really isn't. It would really be October 27th, I believe, 2021. The latest allegedly negligent act pertained to Dr. Jeremy Meeks, who is an unnamed defendant, occurring on February 2nd, 2022. Which is still outside the statute of limitations. So in order for the continuing course of conduct doctrine to extend the statute of limitations, the last allegedly negligent act has to be within the 3-year window, and that's absent here. However, the continuing course doctrine is for situations where the patient has the same care provided by the same provider. Dr. Meeks, seeing the patient taking over as the attending shortly before the L&I claim, does not create a continuing course that encapsulates all of Dr. Wu's care starting in July of 2021, in other words. And plaintiff produced no evidence of any allegedly negligent act by an Evergreen provider occurring less than 3 years ago. So the third issue is equitable tolling. I saw reference to the Fowler case, for instance, the equitable tolling doctrine. This doctrine, to be clear, this doctrine is reserved for extraordinary circumstances, and all of our case law says it should be used sparingly. This is set forth in 16 Washington Practice, Section 10.5. Whether it applies is also a pure question of law, not an issue of fact. That's under the Trotzer v. Vig case, 149 Washington Apt 594. However, equitable tolling does not apply here when there's no evidence of bad faith, no evidence of deception or false assurances by the defendants identified by the plaintiff. The only bad faith identified, or deception, if you want to call it that, by plaintiff is the same as the basis for the negligence actions. But we're talking about bad faith that pertains to hiding the grounds for a potential lawsuit, which, as discussed before, Mr. Childers had active real-time knowledge of during the care itself. There's no evidence that any defendant attempted to hide or conceal allegedly negligent conduct of denying the patient's request for imaging. It occurred in real time. And the patient was aware and frustrated by the conduct and even complained at the time about the conduct to the L&I people and other providers. There's no false assurances by the defendants identified. More germane is the fact that the defendants here, just to be clear, pulling back a little bit, the defendants aren't moving to dismiss on statute of limitations ground. Mr. Childers met the statute of limitations by filing the action on May 1st, 2024. This issue is whether, in the event dismissal is ordered, can Mr. Childers refile the action. Equitable tolling is meant for situations where the defendant shouldn't benefit from hiding the relevant facts that caused the plaintiff to blow the statute of limitations, to not file in a timely manner. That doesn't apply here. It's undisputed Mr. Childers filed in a timely manner. In fact, several weeks before the statute of limitations actually would have expired. So plaintiff's citation to the Fowler v. Guerin case is kind of a non sequitur, Your Honor, because the Supreme Court clarified that equitable tolling cannot apply if the defendant has done nothing to prevent the claim from being timely filed. Again, the claim was timely filed. The issue before the court is whether plaintiff can refile in the event dismissal is ordered. So unless the court has any questions, that's my argument.
The only question I had was related to this issue of extending a statute of limitations for a period of time with respect to a request for mediation. I saw that argument made, and that the suggestion was then the statute of limitations would not run until, I gather, May of 2025.
Sorry.
No. And so I guess my question was, what was your comment or response to that particular?
My comment on that, I saw that argument raised. So there's two things. So under RCW 77110, the making of a good faith request for mediation tolls the statute of limitations for 1 year. If you make a timely tort claim, that tolls it for another 60 days. They stack under the case law. What I saw in the response declaration from Mr. Childers is, in the event this case is not dismissed with prejudice, the plaintiff would submit a pre-suit note tort claim and a request for mediation to further toll the statute of limitations. And our position is those don't apply dismissal should be with prejudice. And even if a request for mediation was made right now, it wouldn't have any effect. It wouldn't have any legal effect.
And so there has not been a request for mediation as far as you are aware.
I have not seen any, and I, frankly, between you and me, I specifically asked the client whether there was any, and they said we don't have any.
Okay. All right. That was my question.
Thank you, Your Honor.
Mr. Childers, this is your opportunity to provide me with any information you think you would like me to know. And so I guess I'm not going to interrupt you during your presentation, but was there anything there that you needed clarification before you begin?
Not that I can think of, Your Honor, no.
Okay. Why don't you go ahead?
All right. For starters, I would like to go ahead and just voice my apologies for not having the tort claim. Also for the issue with the response brief. I'm not extremely knowledgeable in the law. I have not taken law school. I'm just having to take this as I come. There's a lot of visits to the law library with my partner doing a lot of work, and so we're just trying to figure it out as we go. Reading through some of their paperwork, I kept getting a little bit lost, and I'll explain why. So they want dismissal with prejudice because we didn't file a claim form. And they state that we made no attempt. However, during the entire time the L&I case was open, I made frequent attempts to communicate directly with the providers, to communicate with L&I, to do anything possible in order to rectify the situation, to see if there was at minimum a supervisor I could speak to, if not a supervisor, someone I could contact or email, a form I could fill out, anything. And I was led nowhere. The only direction I was led to was to the Labor Department, and Labor Department told me that I could just file a claim and an inquiry with them. They could look into it, and it would go from there. Unfortunately, it didn't go anywhere. But so they want a dismissal with prejudice because we didn't file a tort claim that we didn't know we needed to file, and because it's past statute of limitations. But we can't get equitable tolling to help with the statute of limitations in the claim form mistake because of the lack of proof of bad faith they claim. However, we have evidence of the bad faith, which they're denying, and also due to the fact that they're denying the bad faith evidence, it makes it disputed material fact, which also grants the case merit. And merit commonly supersedes procedural technicalities and errors, something else which should allow us to qualify for equitable tolling, again, which we have the evidence for. But they also argue that the factual disputes brought up do not matter for this motion because they would not change the legal outcome of our case. However, those facts do matter since equitable tolling alters and or controls the outcome of our case, and disputed material fact, again, grants the case merit, leading us back to either dismissal without prejudice in favor of granting equitable tolling, or accepting the currently established merit of the evidence and allowing the case to move forward in spite of procedural errors and technicalities being weaponized in an attempt to further silence me. So on notes on dismissal without prejudice, examples of bad faith would be, one example, Dr. Wu's direct dishonesty. At one point, they had actually kept my activity prescription form from me, claiming that they were going to send it to my case manager, Pauletta Hall, themselves, only to have a conversation with her on the phone telling her that apparently I was actually good to work and I was really fine, even though he had the activity prescription form in front of him the whole time that he filled out stating I was not good to work based upon the physical examination he gave. So there's that incongruency. When I came to pick up the APF later, it was still marked as not able to go back to work. So when I talked to Pauletta and she explained to me that he had told her that I was good to work, I showed her the discrepancy with the form. She noticed that. We couldn't really figure out where to go from there. I chose to request an independent medical exam at that time because of my lack of confidence in the examination. The IME actually did return back that I was not good to work, in fact. The IME disagreed with Dr. Wu's findings. Alongside the whole agenda being pushed of me actually being okay, at some point either Wu, Zender, or another employee of Evergreen entered onto my medical record that apparently I was drug seeking. I have no idea where they got that from or where they came up with that. I hadn't exhibited any past behaviors or recent behavior or anything. I don't know where they came up with that, but that was something else they were using in an attempt to just essentially sweep this under the rug. Sorry. The entire time the case is open, I was in constant communications with them. And I had no knowledge of the actual negligent care or acts or the fact that there was a further injury. I only had extreme suspicions. I had everything but a direct confirmation, which is what I would need in order to have actual knowledge. I would need a confirmation. We were unable to get that confirmation because no further imaging was ordered. Even though at the very beginning with Zender during the initial x-ray, they mentioned a pathology, a deviation of the L4, L5 disc, the exact disc which ended up having the injury that I was worried about them missing. It seems what they're trying to do here is weave together a web of protocol and procedure in an attempt to stymie and silence fact. And basically just silence someone they know is pro se and does not have the same knowledge or the same resources available as they have. I mean, something that essentially their position is contradictory. They argue that my lawsuit was invalid due to a procedural misstep, no pre-suit notice. But they also claim equitable tolling should not apply because I filed on time. They can't have it both ways. If they succeed in dismissing my case, the reality is that I will have been prevented from bringing my claim to court due to procedural barriers, which is exactly why equitable tolling exists. I tried to actively research my legal rights and understand the law. I actively sought legal counsel, but was unable to obtain proper guidance. With my worsening injury, delayed diagnosis, and need for surgery consuming my time and focus, my body in peril, and my mind in peril as well, keeping me from leaving the house, even sometimes during necessity, like missing doctor's appointments. It all prevented me from fully understanding or even being able to comply with the pre-suit tort claim requirement. And again, my mental health conditions further complicated my ability to navigate the legal process, especially without legal representation. Courts have consistently recognized that procedural barriers should not be weaponized to deny access to justice. The goal of modern rules of civil procedure is to minimize procedural traps and to allow cases to proceed on the merits in the absence of serious prejudice to the other parties. And what was that? There's a case reference here that I'm trying to... While they looked at that, they claimed to be prejudiced due to the fact that we submitted only a declaration and not a declaration and a formal response brief. We accidentally, unknowingly, we accidentally put our legal arguments within our declaration instead. Even though that was the case, they have also chosen to address those arguments substantively in their reply. This dual approach suggests that while they object to the form of my submission, they have not been deprived of the opportunity to respond to its content. Therefore, it's reasonable to assert that accepting my arguments would not prejudice the opposing party, as they have engaged with the substance of my claims. as far as the equitable tolling goes, I quote, "We have allowed equitable tolling in situations where the claimant has actively pursued his judicial remedies by filing a defective pleading during the statutory period, or when the complainant has been induced or tricked by his adversary's misconduct into allowing the filing deadline to pass." That was Urin versus Department of Affairs, 498 U.S. 89 111 S.CT.453 1990. Sorry, I'm just reading the whole thing. The court noted that by enacting this statute, the Congress recognized that the filing of the lawsuit itself shows the proper diligence on part of the plaintiff, which the statutes of limitations were intended to ensure. And that's Eid Shahin versus Pizza Hut Incorporated, 973 F.SUPP.113D.con.1997. The misconduct displayed was the failure to order necessary imagery, either CT or MRI, which would have revealed the full extent of my injury. Given the fact that they had already identified the L4, L5 disc as being deviated, when the injury did not improve, and when they had two separate physical therapists telling them that my progress had not only slowed, stopped, but even regressed, they should have had more than enough reason to go ahead and order an image. I don't know under which method that would have been done. I do know, though, that doctors and healthcare professionals do have discretion and can receive overrides to get particular tests or examinations done, even if the initial, immediate circumstances don't quantify or warrant it. We went ahead and also prepared equitable tolling packet as well to kind of help highlight and demonstrate how we meet the requirements for equitable tolling. It's just, it seems to go from one thing into the other, with the main goal being preventing me from bringing material fact in front of the court and in front of a jury. Again, it's like they want dismissal with prejudice because we didn't file a pre-suit tort claim form, and the fact that it's past the statute of limitations. But then they also say we can't get equitable tolling due to a lack of proof of bad faith. However, we have that proof, yet they're disputing it, making the evidence disputed material fact, which grants the case merit, and merit does commonly supersede procedural technicalities. Because, again, courts have recognized that procedural barriers should not be weaponized to deny access to justice. I acted within every amount of good faith that I knew. Repeatedly talking to my healthcare providers directly, calling every single evergreen number I can at primary care, Woodinville, at Sport and Spine, at the hospital itself, whatever else I could dig up. Talking to my case manager repeatedly about trying to find a way around this. Switching doctors wasn't even an option because we're not supposed to switch doctors in an L&I case, even though I had, I had attempted to, specifically because of
And Mr. Childers, I just want to let you know you have about 4 minutes, okay?
Okay, thank you. Ultimately, they're attempting to weave a catch-all net with procedure, completely ignoring fact and merit. They're trying to command the court that they have no jurisdiction regardless of that, in an attempt to order the judge into immediate compliance with their demands of dismissal, fully ignoring the laws in place to protect pro se litigants from weaponized procedural technicalities and errors being used in predatory actions from lawyers with far more knowledge paid for by businesses with far more money and resources than available to the average person. I can't possibly think of any other action I could have taken if I had known that this was what was needed first. I would have taken it. They talk about lack of arbitration. I had no knowledge that that was mandatory, and even then, like it was not about the money for me. It was about getting this acknowledged. I mean, to them, it's just another case. For me, it's a desperate last-ditch effort to at least be fairly heard, or at least to be given a fair fight for what's left of my life. I mean, for me, this case is life and death. We would be more than happy, willing, and grateful to have the opportunity to redo the entire process to ensure the claim was handled first. But we would need to be permitted equitable tolling in order to do so. I mean, with the way that their arguments are tying into each other together, at minimum, it should at least grant me dismissal without prejudice in favor of granting equitable tolling so that we might handle this the correct way,
Okay.
with the proper knowledge. I think that's it, Your Honor. I'm sorry.
Thank you very much. I really appreciate your presentation. Counsel Norman, I have one question for you.
Yes, Your Honor.
Are you aware of a case that tolls the tort claim deadline for any reason?
No.
Okay. Is there anything additional that you would like to add, sir?
Very briefly, I will say I agree with Mr. Childers that there are issues of fact, but the issues aren't material. The issues of fact pertain to the care, the claims of liability, the claims of causation, claims of damages, which aren't being addressed in this motion. The material issues are whether or not the tort claim was submitted and what the legal effect of dismissal in this circumstance are. There's a couple other things I do want to mention. I heard the argument that Mr. Childers didn't have confirmation that they had a potential that they had a negligence claim. Under Zalek v. Everett Clinic, that's not what the law requires. It's what a reasonable patient would be led to believe they have a possible claim. And I heard many points made by Mr. Childers that indicated there was abundant evidence of a potential claim, including the IME where they disagreed with Dr. Wu, including the repeated requests for additional imaging, Indeed, this is exactly why Mr. Childers filed the original complaint in a timely fashion before the statute of limitations. There's no authority I know of applying the equitable tolling doctrine when the party actually met the statute of limitation. So that's all I have, Your Honor, unless you have further questions.
No, thank you. That's good. I have, as I mentioned, I've reviewed all the briefing and heard argument. And Mr. Childers, thank you very much for your argument. I really appreciate you being here and providing that. And I can completely understand how frustrating something like this must be. It does appear to me that you have attempted to pursue your case in good faith. You've done what you understood you needed to do. You filed the case within what would have been the statute of limitations. And those were completely understandable as to why you would do those things. Unfortunately, this case involves some technicalities, and I think you mentioned those technicalities, and we're suggesting that that I might have a way of tolling those technicalities or overlooking them. And unfortunately, in this kind of a case, I can't do that. This is an area of the law that is very technical, and it involves various deadlines. And the courts and the legislature have made it clear that things have to happen within a particular deadline, and that a judge doesn't have the ability to waive those deadlines. In this particular case, the operative deadline is, well, there were two. One is the filing of the original tort claim. That is not a deadline that I can waive, and that didn't happen. And so the underlying case needs to be dismissed for that reason, that the tort claim was not filed before the filing of this case. And so this case has to be dismissed. There's nothing I can do about that. I can't waive the deadline. Equitable tolling or another tolling doctrine which would apply to a statute of limitations doesn't apply to the tort claim requirement. So I do have to dismiss the case. The issue then becomes whether or not the statute of limitations has expired and barring a subsequent filing of a case. And again, here, the law is pretty clear and it's pretty technical. While there are certain circumstances under which a statute of limitations can be tolled, none of those situations apply to this particular case. It does require that the defendants have done something in bad faith to hide the claim. And under the circumstances, I don't find that there's evidence of that. I do find that that the defendants, that the knowledge of what the claim was, or the knowledge of what the injury alleged to have been, was raised more than 3 years ago. It could have been as late. The act could have been as late as February 2nd of 2022. However, that would mean that the statute of limitations had expired on February 2nd, 2025. The only way under any theory that the statute of limitations could be extended beyond today would be if a request for mediation had been filed or served, and I don't see any evidence that has occurred. So under the circumstances, I do believe and I do find that the statute of limitations has expired such that the appropriate remedy is a dismissal with prejudice under the circumstances. Now, I can appreciate how frustrating that must be, and I can appreciate how unfair that must seem. And I understand that, and I appreciate that must be how you're feeling. But unfortunately, the law is very clear in this area, and there's nothing that I can do to be able to to issue an order other than what I've just articulated. Do you have any questions, sir?
Wu's intentional inconsistencies don't count as lies?
Well, the issue is that he did those things in the past. Whether he did or he didn't, I don't know. But on a motion for summary judgment, I accept all of the facts in your favor. So I've taken everything that you have said and said basically, yes, it is true. And the only way that I can rule in the defendant's favor is if I find that even if all the facts that you allege are true, there's still nothing that still, as a matter of law, the defendant wins. And so even if it was the case, which you've said alleged it is, and I believe that for this purpose that is the case, that Dr. Wu did things, those things all happened more than 3 years ago. Now, I believe it's Dr. Meeks took some action in February 2nd of 2022, which would mean that we're now past 3 years from that date as well. So even if the continuing treatment doctrine does apply under the circumstances, and I'm not making a ruling about whether it does, I think the defendant has made a good explain why that would not apply under the circumstances. But even if it does apply, the statute of limitations has expired.
I don't understand what I'm supposed to do.
Well, that's one thing I can tell you, is that you have the right to appeal my decision within 30 days by filing a notice of appeal with the court. That would then give you an opportunity to appeal my decision to the Court of Appeals, which would review my decision, what's called de novo, meaning that they would look at everything that I've done and look at all the documents that are before the court, and they would be able to reach it. They may reach a different decision than I have. And we may be able to, one second. What we may be able to do is provide, what I'd say is there's a law library on the 6th floor of the courthouse, and if you were interested in getting a form notice of appeal, that'd be a place you could go to find the form.
I did everything I knew to do, like while the case was open. I did everything I knew to do. At any point, any of them could have told me that I should file a claim. And they knew I would need to file a claim. And during that entire process, nobody employed under Evergreen during my treatment ever mentioned anything about it outside of going to L&I. They saw my damaged back and directly refused to look deeper. They said that it was only an L4, L5, probably just a strain there, that it wasn't a big deal. I explained that I was still concerned and that I think it should be looked at closer. And they said that if it persisted, they could look at it later. And then I brought it up later, and then it never happened. I don't know what else there is for anyone to do, like, in my position. It's predatory. It's predatory. These healthcare companies, they keep chewing up people like me and spitting us out more broken than we were when we got in. As long as they get their money from whoever, it doesn't matter.
And Mr. Childers, like I said, I appreciate your frustration and I understand it. And I do need to move on to my next case. You're welcome to sit back in the gallery, and if you would like to take some time, that's fine. But I do need to move on to my next case, okay?
What are we doing?
Okay. I'm going to step off the bench. We've concluded this matter, and I am going to move on to my next case in a few minutes, okay? So, like I said, you're welcome to sit in the gallery, move your belongings back there, or if you'd like to go down to the law library, that would be another option.